Number 83, People versus Marcus Brown.
Good afternoon, Your Honors. May it please the Court. Ava Page from Appellate Advocates on behalf of Marcus Brown. I'd like 3 minutes for rebuttal, please.
Yes.
Requiring Marcus Brown to register as a sex offender when the SORA Court, the prosecution, and the Department of Corrections all agreed his offense was devoid of any sexual motivation is irrational. Mr. Brown was not accused of any sexual misconduct. He was not indicted for any sexual misconduct. During his incarceration...
How is this different from Knox?
This case is different from Knox in 3 crucial ways, Your Honor. The first way it's different is that here we have an explicit judicial finding from the fact-finding court that this offense was devoid of any sexual conduct or motivation.
Wasn't that assumed in the Knox decision?
Well, in Knox, Your Honor, the prosecution in all 3 cases actually argued that the possibility of a sexual motive could not be ruled out.
No, but when it got to the Court of Appeals, there was an assumption made in the decision that there was no sexual, dimension to the crimes.
Yes, Your Honor. The court did make that assumption, but it did not have the explicitly clear judicial finding that was uncontested by the prosecution
So a
that Mr. Brown
judicial
has.
finding makes that a substantive due process violation? When we were assuming it in Knox, I have a hard time equating those 2 things.
It is one of the factors that makes it a substantive due process violation here because it's irrational to make someone register under SORA.
Because it seems to me we assumed they were making someone register under SORA without a sexual component, and our focus was on the legislature and what the legislature intended, and we found that's what they intended, and we assumed there was no sexual component, and we said there was no substantive due process violation. It seems your rule would leave that in the hands of docs or the Supreme Court to override the legislative determination we've upheld in Knox.
No, Your Honor. The statute itself would stand, and kidnapping and imprisonment offenses against minors would still be presumptively registrable.
So you're not asking us to overturn Knox, you're claiming it's distinguishable, is that right?
Yes, Your Honor. If the court would like to overturn Knox, obviously we would invite that, but
I didn't
the court,
see that in your brief, though, just to clarify.
Yes, the court does not have to overturn Knox to grant relief to Mr. Brown here. So looking at the facts of the Knox cases, they are very, very different than the facts in this case. Not only was there no explicit judicial finding that the offense was a completed, financially motivated burglary and robbery that was devoid of sexual motivation, which the prosecutor agreed with, but there was the Department of Corrections finding that this offense involved no sexual motive to such an extent Mr. Brown was not permitted to participate in sex offender treatment. None of the Knox defendants had that. And then finally, Your Honors, looking at the facts of the Knox cases compared to this case, it's clear that the Knox cases are distinguishable.
Why is that?
Well, in Knox, the first case involved a defendant who tried to grab a stranger 8-year-old child off a playground and who was stopped.
To replace a child she had lost, right?
That is what the court inferred from the record, but there was no explicit judicial determination.
You would draw a distinction between stranger and family? And if so, what's the basis on which it would be appropriate for us to do that?
That's not the rule that we're asking for, Your Honor, but in Knox, the court did rely on the rates of sexual abuse and some non-family member kidnappings to find that it was rational to apply the statute.
If it's a basis for distinguishing it, I assume that you think it's a distinction with a difference, right? So I'm just trying to understand how are we on the record in this case supposed to grapple with the question of, what to make of that study and whether that particular factor makes a difference in terms of whether it's irrational.
Sure. You don't have to grapple with studies when you have the facts of an individual's case, when it makes it clear that the hypothetical danger present in some kidnappings and imprisonment did not happen here. And looking at the second Knox case, Centrone, that defendant had already committed sexual misconduct against a child. He had already been convicted of it before, and he had committed sexual misconduct in prison. The third defendant in the Knox case, Jackson, was a pimp who abducted a child to force the child's mother to prostitute. So all of these offenses are very different than what we have here, which is a completed, financially motivated offense where the SORA court found that Mr. Brown's only motivation was to steal money from an adult, that there was no sexual contact or motivation, but the court itself stated it felt constrained, even though it did not find Mr. Brown to be a sex offender, to require him to register under SORA, even though he posed, and I'm quoting from the court's decision, no risk of sexual threat at all.
A court essentially, with the consent of the parties, or maybe you would require the consent of the parties under your rule, I'm not sure, but could overrule the legislature's determination that this person should register as a sex offender based on the specific facts of the case and a finding by the court. Would that apply to other sex offenses where the court just felt, there really wasn't a sexual motivation here after all?
No, Your Honor, this would be an extremely narrow category of
But
cases.
why not? Why, if the court made a finding in another case and said, you know what, I see this case, but I don't think there was a sexual motivation here, it's a due process violation?
Well, because, one, the court could fashion the rule in a narrow way to only apply to kidnappings and imprisonments where there's no other charge or conviction of a sex crime. If someone is
This has been
accused...
labeled a sex crime, registerable crime by the legislature, so we're essentially giving an override.
No, because the statute remains the same. This only allows the risk level court to determine, based on the specific facts of an individual's case, if there was clearly no sexual motivation or conduct, SORA does not apply.
If they found that in another crime, where arguably, there always is, but here, I really don't think so. I think they got it wrong. I believe this guy. I'm not going to register you. That would be a due process violation. I'm finding there was no sexual motivation here.
Your Honor, this is why this shows that the SORA hearing is the perfect venue for this, because at the SORA hearing, the court is already determining registrability and determining someone's risk of reoffense. So
What if Doc said, we don't know, and the court said, no, I'm finding there isn't? What would the rule be?
I'm sorry?
What if the people objected or Doc said, no, there is a hint of it, we can't be sure, but the court said, no, I looked at this and there is none. Who do we let make that decision then?
Well, in that case, so here we have clearly an indisputed case that did not involve any sexual motive. I think that's easy, and I think the court should have been allowed to do what it was trying to do, which is to exempt Mr. Brown.
But what if you don't? What's a split decision down there?
If it is a contested case, Your Honor, the prosecution and the SORA court are allowed to introduce all relevant, reliable hearsay evidence. This is already the rule at all SORA hearings.
What if they say, look, we just don't know, could be, could not be, what you characterize Knox as? And the judge says, yeah, I don't think so. Is that enough?
Well, at the SORA hearing, Your Honor, the prosecution can introduce the complaint, the pre-sentence investigation report, the grand jury minutes, trial testimony. The court can even look at counts of which the defendant was acquitted.
I think what Judge Garcia is getting at is how would you articulate the rule that you would like us to adopt?
Okay, my proposed rule
Yeah.
is that when it is indisputed that a kidnapping or unlawful imprisonment offense was devoid of any sexual conduct and devoid of any sexual motivation, applying SORA is irrational and
Yep,
should
sorry,
be
right.
exempted.
And by undisputed, you mean the people agree, defense counsel agrees, the court agrees?
Yes.
Docs, or the board agrees?
Yes, that is the first part of the rule that
So
applies to
everybody
this.
involved agrees?
Well, DOCS doesn't need to be a party
Right,
because
but
it is
the board?
Yes.
Board's recommendation.
well, the court and the prosecution. So that's the first part of this rule. The
What
second,
happens if the board has not agreed?
well, the board just, in this case, the
Yeah.
board said this offense lacked a sexual motive, but they just automatically
Right.
issue the paperwork.
Right.
So I think it should be a judicial finding after considering all the evidence. To
So
address
if
Judge
a court,
Garcia's,
if a court overrides the board and says there's no sexual component, would that be enough in your view?
no, this rule would only apply to a very, very, very narrow category of kidnapping imprisonment cases when the person has not been charged with.
Counsel, I'm sorry to take you back several questions ago, but I just want to confirm, in your distinguishing of Knox from this case, the factors that you used, the last one, facts, are you saying that the fact that the defendants, none of the defendants in Knox were family members and that the defendant here is a family member, that's not something that you're pointing to as a relevant distinction?
It is a factor, Your Honor. The three crucial distinctions I'm pointing to are the explicit judicial finding, DOC's determination, and the facts of this completed case as compared to the Knox cases. So one of those facts in the case is that this child was Mr. Brown's blood relative, his cousin that he grew up with. So it doesn't strike the same fear that the legislature had in making these presumptively registrable to protect children from stranger kidnapping.
Well, that's my concern, though, because I thought I detected a suggestion in your brief that somehow the fact that it was a family member can, just what you said, that it doesn't raise the same level of concern. But I don't know that the record supports that particular contention. So that's why I'm trying to understand exactly where you stand on family member.
Yes, Your Honor. The reason that I brought that up is because in Knox, it was largely based on these two studies about rates of sexual abuse and some non-family member kidnappings. However, I don't think it's what makes us entitled to the relief that we want here.
So if you had someone who was a family member, but there was no judicial finding that there was no sexual component, no sexual risk, you would not have the same argument, I take it, that it's irrational, that you are
Correct.
presenting to us.
Correct, Your Honor. And I want to point out that in the 14 and a half years since Knox was decided, it's become clear that not only this is a very narrow category of cases, but it's actually quite straightforward to determine when an offense like this is devoid of sexual motive. In Eunice versus Robinson, a federal case from 2019, and again in Pennington versus Rosado, a federal case from 2022, the federal district courts considered applying SORA to two defendants convicted of a non-sexual kidnapping of a child. So registrable, same as Mr. Brown. The district courts there held that it was irrational to apply SORA when it was indisputed that the kidnapping lacked any sexual motivation. And New York State then exempted those two men from registration, identically situated to Mr. Brown, except those men had the money and access to sue in federal court. That further underscores how irrational it is to apply SORA to Mr. Brown.
Do you have a sense of the numbers of individuals that fit within this narrow category we're talking about, this provision of the penal law that then are required to register as sex offenders?
I can tell you anecdotally, based on my office's experience representing hundreds of SORA subject people post-Knox, this is, of all SORA cases, this is probably 0.001%. I myself have had 2 of these cases, this case and another one.
When we say these cases, just to be clear, they are individuals who are convicted of this particular, or these crimes that fall within the definition of a sex offense crime, and who had no, in your view, have no sexual motivation, sexual act, or that they just were convicted of the crime? Because I'm asking about the latter, just convicted of the crime.
Yes, just convicted. The 0.001% are people that are only registrable because of an imprisonment or kidnapping offense, who have no other sexual charges or indictments on their record. So not a case where someone committed a kidnapping or rape, not a case where someone committed an imprisonment and sexual abuse. Cases where the person is solely registrable because of one count in the indictment that they pled to that no one seemed aware was
Cases
SORA
like
subject.
Knox. I mean, again, I can't get away from, I don't see it being distinguishable from Knox. And
Well-
unlike the federal courts, we can't decline to follow our own precedent.
Well, Your Honor, this court has never hesitated to step in when SORA has impinged on an individual's constitutional rights. So even if this court finds that Knox was the right decision, I think the years since have shown that the SORA hearing is the place to make this determination, and applying the enormous stigma and burdens of sex offender registration on someone who has indisputably never committed a sex crime nor tried to commit sexual misconduct is simply unconscionable.
May I ask, do you, from your position in this case, do you agree with the way the court in Knox defined the defendant's interest?
In that it's a substantial liberty interest?
Yes, but the way it continues to define the interest about the mislabeling, do you agree that that is a correct characterization of the interest?
I think that in the years...
Narrower, is it broader, is it different?
I think in the years since Knox, we have become more aware of the dire consequences of sex offender registration. The court in Knox said it was merely a label that was no less worse than child predator. But even the New York State Unified Court System, its own website now, lists that sex offender registration can lead to social disgrace, humiliation, the loss of relationships, jobs, housing, verbal and physical abuse. And in my brief, I address this extensively, but even as a level 1, which Mr. Brown is, in 1 year alone, over 28,500 calls were made to the registry. The majority of those were to the hotline where level 1s are listed, and they were made by potential employers screening applicants. So I think in the years since Knox, we as a society have become aware that these burdens and consequences are real and they are lifelong.
So you're saying that in the almost 15 years since Knox, that if we now look at the interest, it is one that perhaps has some is broader in reach than it was at the time that the court considered Knox?
Yes, Your Honor. And I would also, I see my time is up, I would just like to conclude that in Leiden, which came after Knox, this court held that allowing the risk level court to decide the registrability issue is not just an efficient way to proceed, it is good policy. And it was precisely good policy in Leiden, this court held, because it avoids putting the court in the uncomfortable position of deciding the risk level of someone that the court is not convinced is a sex offender within the meaning of this statute at all. That is precisely what happened here.
Thank you.
Good afternoon, Your Honors. William Brandinger for the Office of District Attorney Katz. May it please the Court. Your Honor, this Court should follow its own precedent in Knox in holding that the automatic registration requirement is rationally related to the legislature's goal of protecting children, in particular, protecting children from sex offenses.
How does it protect the public when there's no dispute, there was no sexual component or motivation involved?
Your Honor, as discussed in Knox, when there are certain kinds of offenses against children, and this comes from the original Jacob Wetterling Act in Congress, that certain crimes against children, that including unlawful imprisonment and kidnapping offenses, are related or have shown to be related to...
But when there's an actual factual finding,
Well,
that there isn't, the risks that they're supposed to be protected are not present in a particular case.
Again, Your Honor, this was already addressed in the Knox case, and the fact that this is an intentional part of the statute.
But doesn't the Knox case deal with the issue of when it's not clear, there's a rational reason, the protection? You don't have, there's a burden for the government to have to prove in each and every case, and sometimes they can't, but because there's a question mark, they should be registrable.
Your Honor, the way that the Knox case was decided was explicitly on this issue of whether the absence in the record of those cases, or in the absence of a finding of a sex offense in those cases.
So in the Knox cases, you're saying there was no dispute, that there was no sexual component or motivation?
Well, there was certainly no dispute in the appellate record. The people might have challenged that at some point. I don't know that, but looking at the case itself, those were 3 cases where this was absent and the specific issue was raised as far as substantive due process. And they said despite that, for the legislature, under a rational basis test, could find that the automatic registration requirement was necessary. So
Let me ask you this. Suppose, just hypothetically, that every time one of these cases came up, the federal courts were going to throw it out on habeas. That's not true, but let's just take that assumption, okay, for the hypothetical. Would that be a reason for us to think about revisiting Knox?
Well, no, for the following reason. Your Honor, the problem with this, what I have with these particular Southern District cases here, is it involves essentially the same case. They're co-defendants. It is a full kidnapping. A child is, 14-year-old boy, I think, is taken. He is held for several days. He's handcuffed.
Now, that's not my question. Suppose it's cases with facts just like this. And we know now, 14 years later after Knox, that the federal courts are always going to throw this type of case out. on habeas, the narrow one described by Ms. Page, does that affect how we should think about our prior precedent, whether we should carve out something to avoid the federal courts from having to do that to us over and over and over?
Well, first, Your Honor, no, Your Honor, this court should follow its own precedent. But I would also say that here, in addition to the facts of that case, and I would say that the facts at issue in Eunice are the exact reason why we have an automatic requirement and we don't permit, or the legislature did not permit factual findings and a possible determination by a court. But those are Southern District cases. The Second Circuit has not spoken on this. A number of state courts have. This court chose to follow those other state high courts that adopted
But
a strict...
it is one thing to say the legislature could paint with a broad stroke, and it's another thing to say, but then when presented with an actual factual case that does not fall within any of the concerns that the legislature had, shows that there is no sexual motive or sexual act, that there is no relief available to that individual from what is clearly the stigma associated with this compromising of their liberty interest. It strikes me as these are two different things.
Your Honor, there was a choice made, and the choice was made to include a certain narrow category of crimes against children. And if you look at the purpose of the statute, which involves basically giving notice to the public, to a school, that they might have someone who, under the statute that they passed, is a sex offender, and to give notice. And they intentionally included people who committed unlawful imprisonment and kidnapping against child because the society they chose to give society that protection.
Of a possible risk, but the purpose of SORA, right, I agree with you, is of course, and we've said it before, to protect the public from sex offenders. But when you have an actual human being before the court, the conclusion is this is not a sex offender. There's no sex act, no sex motivation involved in the crime. Again, that strikes me as different from saying the legislature could broadly include people and a crime within SORA, but once it's presented that someone falls outside of the scope of the individuals you're actually concerned about, that courts can give no relief to that person. It strikes me as two different things.
But the legislature made the determination that those categories of criminals, the kidnappers and those committing child imprisonment, were part of the group that they wanted to protect society against. And they did that, again...
Sure. Oh, I don't disagree with you there. But one can do that without imposing the label of a sex offender, which is an inaccurate characterization of the individual's criminal act. You can label them a robber, a burglar, a thief, whatever you want to label them.
Your Honor,
This is about labeling them a sex offender.
correct,
When they
Your
are
Honor.
not, in that sense, right? That's nothing involved in the crime is any way associated with the sexual component.
Correct, Your Honor. And this was specifically held in Knox, that labeling itself did not violate a substantive due process or the liberty interests on a rational basis test. It said that the legislature could, if it had wanted to, label it sex offenders and child predators. It chose not to do that, and it has not done that since the Knox decision came out. It has not either changed the labeling or created this type of process where there would be a determination made by the original court, which I think would be original court from the judgment, but the original court to say whether this was a registerable offense or not. So they chose not to have that process, and that was rationally related to the legislature's objection under due process.
Was this a plea?
This is a plea, Your Honor.
And was it a plea to the entire indictment?
It was a plea to the entire indictment. So that's why there was, you have a plea to the burglary and robbery and to both of the unlawful imprisonment counts. If the court has no further questions, the people rely on the brief. Thank you,
Thank you.
Honors.
We're not challenging the validity of the statute. We're simply asking for the same principle that this court upheld in David W. and in Leiden.
But counsel, I don't see how you're not asking us to overrule Knox. Here's the holding in Knox, the holding. But even on the assumption that there was no actual or potential sexual aspect in any of these crimes, we hold that defendants' constitutional rights have not been violated. And the difference I think you're explaining to us is the difference between we assume the record says that there is no potential actual sexual component to these crimes where the record actually says. Isn't that the only difference here?
I mean, that in and of itself is a gigantic difference. You have
Because
an
we assume the
explicit,
record says, and in this case, the record actually says.
I mean, yes, that is a huge difference. Assuming and not knowing is the very thing the legislature was concerned about in making these presumptively registrable.
But
When
we weren't assuming we didn't know, we were assuming it said affirmatively there was none.
Exactly, Your Honor, but assuming is different than knowing. And here, not only did the prosecution agree, which they did not in Knox, but we have the SORA court that reviewed every single piece of evidence in this case.
So wherever we assume a fact as part of our holding, if the fact is proved in a later case, it's a different case.
I don't think you have to make such a broad rule, but I think in this case, there is a difference between an explicit court finding by a fact-finding court and this court being left to assume because it was never found. It outweighs the relevance of studies and statistics when we know that in Marcus Brown's case, there was no sexual motivation, that the prosecutor agreed, that the court agreed, that the prison agreed. That makes it irrational to apply sex offender
Isn't there
registration.
another difference in Knox? Granted, it's not the primary statement by the court that equates those particular parties labeled as sex offenders as child predators. How is this defendant a child predator?
He's not. The court made that explicit finding. The child was not targeted, he was not abused, he was not abducted, he was not
That
detained.
happened in
child was
Knox as
held-
well. There weren't child predators in Knox. In Knox, they were being extorted for money. There was no finding that they were child predators. Again, regardless of the value of Knox and whether we should revisit it, distinguishing it here, I find very difficult because it was the same scenario. They were also not child predators.
And the Citron criminal history goes only to the argument he made for a level departure. They didn't factor that in at all in the original constitutional analysis.
Well, Your Honor, the SORA court should and does look at someone's background to see if they have ever committed sexual
You're trying
misconduct.
to distinguish Knox based on the sexual background of Citron, who locked his partner or something in the apartment with her kids. And you say, well, Citron had a sexual conviction for a sex crime, but the court didn't consider that at all in the analysis of the constitutionality of the designation. It considered it only in the argument Citron separately made for a departure.
Yes, Your Honor, but it was a fact of that case that the SORA court could have considered were Centrone to get a hearing on whether he should have to register.
Counsel,
So-
wasn't the child here, if I'm remembering correctly from the record, held at gunpoint?
Yes, that's what the unlawful imprisonment count was based on, the presence of a gun
So
at the
how
home.
does that sync with your argument that the child was not targeted at all?
That was the SORA court's finding, Your Honor, and my argument is that this is a sex offender registry. So if the legislature wanted to create a crimes against children registry, this would be a harder lift. But this is a sex offender
I thought you had
registry.
distinguished Knox on an additional ground, maybe I missed it, but I thought you said this earlier, that in Knox, what the assumption was that the crimes had no sexual component, and that here there was a finding from the SORA court that Mr. Brown posed no risk of sexual offense.
Yes, Your Honor.
Those seem like different things to me.
Yes, thank you. Those are very different things because none of the Knox defendants had those, and the same certainly could not be said for at least Centrone and Jackson. I also think it's important to
But that's
note.
a finding a SORA court makes all the time, right? What's the risk of reoffense? And that can go to what your level is. But now we're going to use that to distinguish Knox and say you don't have to register at all.
In this very narrow category of cases, due process demands that if someone is not a sex offender and has never committed any sexual misconduct, that the court be allowed to exempt them, yes. And I think it's very important to note that New York State itself has exempted at least 2 people who should be registering under SORA. Eunice and Pennington were exempted by New York State of kidnapping a minor with no sexual component from registration. That's had no effect on state law. It certainly had no effect on federal law. And we just ask that the same treatment, the same chance be applied to Mr. Brown, who had an explicit court finding. He does not pose a risk of sexual threat. He did not commit any sexual misconduct nor tried to. This court in David W. said, striking down an automatic SORA designation without opportunity to be heard, that due process requires that the state bear the burden of proving at some meaningful time that the defendant deserves the SORA classification assigned. So if we are simply saying what the SORA court found in this case didn't matter, what the prosecution agreed to didn't matter, that is a due process deprivation. It is irrational. It conflicts with federal court decisions. It conflicts with New York State's own exemption of identically situated defendants that had more money than Mr. Brown and were able to pursue the case in federal court. That is irrational, and it is unconstitutional.
Thank you.
Thank you.